G'day, Nina. How are you?
Good, thanks, Andrew. How are you?
Not
New
too-
setup.
New setup. I like it. I really,
Yeah.
really like it. Actually, it's
Feels more us.
it does. It feels much more us, doesn't it? Thought before we started today, we'd have a chat about with this director case that came a while ago.
Yeah, that was really interesting. The one who got acquitted.
Yeah, he got acquitted for breaches of duties in relation to two people being killed on a high line.
The zip line accident.
Yeah.
She was managing director.
And look, the case. The only part about the case that I do love WorkSafe getting orders of costs against them. They're very substantial order of costs. But actually, what's really interesting about this is something that you and I find every day, and that is when WorkSafe or the regulator investigate, they're just people.
Yeah.
Okay. I ran criminal trials when I was young, and trained professional police make dreadful mistakes in their investigative process. They fail to measure something accurately. Small things can be big things in a piece of litigation. And in this case, I don't think the magistrate was the most generous I've ever heard of a magistrate, because he said the investigation was fine, but the diligence was flawed. I don't quite understand how that works. But the bottom line is...
I think you meant like the overall WorkSafe investigation of the event, like the incident itself. But the investigation into the managing director's due diligence was completely flawed because there was no reasonable basis to go down the prosecution route.
No, but I think, as we look at prosecution briefs and we come through, and we always, my rule of law is you go to locus inquiry. You go to where it occurred and you go and look at what they're saying. How often when we take our brief and we go and look at what they're saying, they're just completely wrong.
Yeah, it's actually happened a couple of times.
So I want you to remember, don't panic when you get the brief. Don't put your hand up and plead straight away.
Yeah.
Pick your brief up and go and test it against. If it's a due diligence things, what were the things that you did? Well, why haven't they got those here?
Yeah.
In this case, none of that proper inquiry was undertaken. It was a sort of a more emotional attack on the director, which always happened in highly politicised case where there is a death of somebody who's on a tourist.
Yeah.
Yeah.
And in this case, there was clear evidence that really the responsibility fell on the operations manager who had full control over WHS and around the infrastructure. So had they done their own due diligence,
that's exactly right, isn't it?
They wouldn't have been, it was like $200,000 in costs. Yes, yeah.
Now, look, the other thing I wanted to say is, remember, I loved actually someone coming up and recognising me. So to the people from Warrnambool who recognised me when I was out in the middle in Canberra and said hello, B-grade celebrity, or D-grade celebrity.
Yeah, I don't think you're a B-grade celebrity.
E-grade celebrity. But it was great to be interrupted in my meal by somebody who watched. And I want to thank them for doing that, because you made me younger and feel more important just like that. All right, perhaps if we can go on to Whitnall and comfort. I reckon that this bullying case is fascinating. Okay, so in bullying cases, for a stop order, what you've got to demonstrate to get an order is that there is an ongoing risk of bullying to a person.
Yeah.
So if the person is terminated, or if you relocate them to a place where they can't be bullied, you can't get a stop order.
Yeah.
So that's good to know, isn't it? But what's even better to know is, and I don't think this is right. Can I say that I think this is a bad decision? I just want to add that. This is where they said, well, you're not at a workplace because you're on workers' compensation.
Yeah, they made the claim while they was on workers' comp because people had been talking about their workers' comp and questioning their lives and stuff.
And it was said, and I don't think this is right. I just want to say I don't think this case is right because it misunderstands psychological hazards. Is it doesn't matter if you are employed at work. I don't think it's designed to prevent a person who's not at work being harmed by bullying that is occurring at work. Anyway, this case says the person's on workers' comp and they're not at work, and the nature that a stop order doesn't apply because they're not faced with the bullying effectively. And I think that's horseshit. Oh, I think that's not good.
Yeah, because I think then that would leave it open to things like if it's online and things like that.
Yeah, it's nonsense. But anyway, it is what a decision has been made, so we're bringing it to you straight away. But I wouldn't follow it. Okay, now I think bonuses are funny things, and this is a New South Wales case. It's Millicent, a New South Wales case. It's around a deed of release with a person, I think it was a doctor who was leaving. There was a piece of proceeding around between the employer and the employee.
Well, so it's a little bit complicated. So the employee left their previous employer, started some kind of proceedings against them, and went to work with not a related company, but someone that then had done work with while they were employed with the first employer. And then with the new employer, they hadn't disclosed about their ongoing proceedings, and they were promised that if the new employer sold the company, then they would get a long-term incentive.
Yep.
And then what they settled the proceedings with the previous employer with a deed of settlement, which, as part of the release, said that they weren't entitled to anything further from any of the group companies related
Yes.
to the first employer.
In relation to their employment.
Yeah, so the deed was in relation to their employment.
Yeah.
And then
can I just say, it was any services in relation to their work. So there was quite clear words that were used.
And then the new employer disclosed that they were sold. They're sold to the previous employer or like a related company, something like that. So then the employee decided to resign from his new employer and expected to be paid the long-term incentive, and they said no because we're now a group company.
That's right, and the deed of release applies.
Yeah.
And Rothwell, who's the Chief Justice, very incredibly clever, was a great barrister on usually against the work deed because he was normally employee based, but looks carefully. Now, when you do a deed of release rather than an agreement of release, it's very different. Agreement of release has consideration. So if Nina and I have a disagreement and Nina agrees to settle it and to receive a payment from me of $60,000, and there's consideration between us, we do it by agreement. The construction of the agreement will be to give it commercial sense, okay? But if I use a deed so there doesn't have to be consideration, okay? So I use a deed, then it will be construed against the person that gives a deed. So if I've terminated Nina's employment, which I never will, and as part of that I say, we'll pay you this, the deed will be construed to the benefit of Nina against me because it is a deed, not an agreement, okay?
Yeah.
And that's really important. That's why in an agreement and also in a deed, if it's highly contentious, they've had the opportunity to provide legal advice to turn around that onus that exists. So here, when a deed says in relation to services that are provisioned, the sale is a triggering event, it's not a service.
Yeah.
Okay. And therefore it stays alive because you construe it against the giver of the deed. So,
and it wasn't related as well. He started his employment with a new one after he'd left the other. So it was completely unrelated.
But look, I think it's interesting, and I want you, a number of people will go and just use template deeds. I want you to remember templates are always dangerous.
Yeah.
Unless you understand what you're doing and how it actually works, it creates very genuine risks. So please don't just take one off the shelf and get people to sign it. Different circumstances, particularly people with incentive programs, performance programs that sit inside something, you cannot do by an off-the-shelf. Anyway, that's a bit of lecturing, but I think it was a great case and look, great judge. So
yeah, that was a really interesting case.
I reckon Farrell was a pretty interesting case. The next case as well.
Yeah, so about swims.
Yeah. The facts in this, Nina, I think, are not terribly. I mean, they're awful facts. They're a dangerous trench. There was a swims, the walls collapsing, all the things that should happen. But what? And there was a significant fine that was handed out. It was a prosecution that occurred to the employer. But the thing that came out of this case, and I guess there's a piece of law that is very simple that says you can't contract out of safety law. Okay. You can't have policies and procedures that seek to exclude a liability through the use of the policy and procedure, and you can't do it through a SWIMS. Now, they are all indices of obligations that exist. So a contract does come into the paddock of things you've got to consider. But the bottom line is, if I ask Nina to get into a ditch, I, as the person, I have an obligation to be satisfied that that trench is safe. I can't make that Nina's obligation. Nina has an obligation to do certain things that exist under safety law too. But the idea of having a SWIMS, which is highly complex, which nobody will follow, is flawed. That's exactly what the judge said here. But secondly, trying to ease off responsibility for duty holders to other people will not work.
Yeah, it was really weird in this case because we're normally used to people trying to say, oh, it's your responsibility, not mine. But in this one, the SWIMS was super detailed, but yet they were like, everyone's responsible, so no one was really responsible. And because no one really took responsibility, they didn't have any supervisor who was making sure it was implemented.
Yeah.
So it was a useless control.
So when you look at a risk assessment process, SWIMS in some ways are the world's best version of what a risk assessment should look like, because it goes through sequentially each hazard as you approach it. It rates it and it creates a responsibility. Now you hear the last part. So it rates it and creates a responsibility. And so if I look at a trench, there'll be a number of different people who have responsibilities, but they are very specific. And normally the contracts that govern who do that work will be, we will provide you with a trench. Here's the geotechnical evidence that sits around the trench. You will dig the trench. This person will operate inside the trench to do the piping. So when you go to do a SWIMS, sit down and look operationally what are the roles that people are carrying, because that informs the duty. That says to you what is reasonably practicable. But if you try and capture it by, again, off the shelf SWIMS, which just cover everything, and you go, well, we're all responsible for making sure no one gets crushed. Well, that's good, but it doesn't identify, because SWIMS sequentially manage each hazard by obligation. And if you can remember to do that, then they're a terrific document. But if you make it complex, you make it tick and flick, you make everyone responsible, what you do is you make everybody liable.
Yeah.
And everyone in safety has the same levels of liability. It's not a zero-sum game. So I put this case on. I know, Nina. I put it on because I think every time we come across this in a safety prosecution, the SWIMS is the first place the regulator goes to, and they have just these comments.
But it should also, it's just crazy how much people misunderstand the use of SWIM. So it's just another reminder that it's a really good tool if you use it correctly.
Yeah, I agree with you. Well, look,
All right.
I love psychedelics. Can I just say?
There's a quote.
I love the Sawley case. I reckon
This one's pretty funny.
It's pretty funny. This is
Yeah.
a group of people who are in a treatment facility. Somebody who's
Like a rehab treatment.
An employee
A
bags.
supervisor as well.
Supervisor bags the institution they're in. But not only that, suggests that magic mushrooms could be a good treatment for them.
Yeah. To these people who are in rehab.
No, I love mushrooms. I love risotto. But magic mushrooms, I'm not sure is the greatest treatment for people with mental health issues,
No.
drug related. But anyway, not surprising they were sacked.
Yeah, but then brought a general protections claim.
They brought a general protections because what did they say?
Said they'd made safety complaints and other things.
From cooking mushrooms burnt or something.
Flexible work
Sorry.
requests and stuff like that.
Anyway, look, the judge, I think at that time, the deputy president had a bit of a chuckle, I suspect, and said, look, I don't think it's a good thing that you're suggesting to use magic mushrooms and that you're bagging the institution, and it's clearly incompatible with your role, and therefore you're sacked.
And it overrode the procedural deficiencies,
And so, again, you can see that I've had a hand in choosing the case. I love this because if you do something bad enough, but you stuff up the procedure, everyone goes, it doesn't matter.
Yeah.
So don't bugger up the procedure. Don't muck up the procedure, but please just be aware.
Funny, because I think that leads very neatly into our next case, which is related to procedure.
It does. Yeah. Look, this is a funny case. This is application by Hawthorne Plant Logistics. Oh no, that's the EA one, isn't it? No, this
is the Nigel McLaughlin one.
Nigel McLaughlin case.
It's about wage theft.
Oh yeah, this
alleged wage
theft.
This
is the person who was sacked for fraudulent timesheets.
Yeah, allegedly put in timesheets for time that they were recording.
So can I want to stop there for one thing. When you allege fraud in any process, as a lawyer, we can't actually allege it without actual evidence to prove, because it's a breach of our professional duty. But it shows that courts are most reluctant to hear evidence unless you have actual evidence of fraud. So the assertion of it is something you want to be really careful about.
But they went further, Andrew. They didn't just assert it. They just, in telling them about the allegations, gave a termination letter and just said, yeah, you're being fired because of these things. We've got the evidence. We're not showing it to you. We're not giving you an opportunity to respond. You're fired.
Yeah, that's not good, particularly when they didn't have the evidence.
Yeah.
But they did have evidence of consistent underperformance.
Yeah.
And
had been warned twice before.
Yeah, and at the end of the day, his termination was held to be valid, but on a different reason, wasn't it?
Yeah. So had they terminated for the performance, then they would have been fine. But because there was no evidence of the wage theft and they failed on procedural fairness, he won. And I think he got a week.
He got a week. Yeah. They got a pat on the back.
Had they chosen the right reason, they would have been fine.
Yeah, you can't help feeling. I was saying at a presentation with our friend Simon Booth just yesterday up in Wagga Wagga that you need to be careful of people who really get you down. You become so highly sensitized. So
Yeah.
you see this time thing, you don't have any evidence, but it just blows your head off. But you always, if you had have dealt courageously with a person, had a basis to terminate another way. But you don't. You go through this new thing and you go, oh, this is terrible. And of course, you don't think through what the consequences are. Now, here you spend a whole lot of money and you pay an extra week. Okay. But if you had it done it the right way, you probably wouldn't be spending any of the money at all. Anyway, good case. Can we go to the EBA one?
Yeah.
Because I'm sorry, I got a bit
I
excited.
think this one is very interesting.
Yeah. This is a case where enterprise agreements rolled out, CFM a year on the other side. The business involved only has, when you look through the classification system, only a few of those classifications with people in. The bottom two classifications don't meet the boot test.
No, they were too low.
The method of representation of what an agreement was not accurate when it was given out, and there wasn't sufficient people to vote.
There was 18 people to
vote, given the impact it would have on other people.
Yeah.
And
so they were paid significantly higher than the board, but there were other people underpaid, and obviously they don't care about that because they only represent the higher group.
That's right. And it's one of these things. This is an old IR consultant strategy, which is you go in early in a business, you have all the people who are paid really well, and if they're not paid well on the books, they're paid well off the books. They vote up an agreement.
Oh my gosh.
No, it's true. It's what used to happen.
Wow.
In fact, they used to drag them from. So the old way of doing it was you used to get a labour hire company to come in a greenfields, for instance. Okay. So you didn't got away with the greenfield, didn't have to do a greenfield with the union, and then those 5 or 6 people, you'd pay them wildly over the top of what they're being paid through the labour hire business, and then they would vote they'd roll on as employees, and they'd vote up an agreement which affected 5 or 6 classifications that they didn't even cover. And not surprisingly, there's a few decisions back when I used to work with IR consultants that beat that to death and said it's wrong. And that's what 182 is. It's the 182, isn't it, that I'm looking at?
188.
182. Yeah, 182. 82 that I'm talking about.
Voters have to have a sufficient interest.
It's really how this clause was generated from the older provisions that exist in the prior act, is to say, look, actually you've got to test it against every provision, and for people to vote, they've got to have a sufficient interest in what they're voting in. So I thought it was a good case.
Yeah, because I think in this case they also tried to say, oh, we don't really employ people in those classifications, which I feel like
often, as they said, often. Yeah.
Which in the past has probably worked with the Fair Work Commission, but I think with this clause they were like, no, that's not good enough because it's clearly contemplated by the enterprise agreement and it exists.
Yeah.
And they wouldn't enter into undertakings as well. Yeah. Silly.
Isn't it funny, the Fair Work Commission.
On to the main topic?
Is it? Before we do.
Oh, okay.
The Fair Work Commission is an odd place because it's a place that gets things done. So, in enterprise agreements, we're regularly making undertakings because it's a shifting sand. When you're in the middle of an enterprise agreement, people make decisions about clauses. They don't come to us. By the time it hits our desk, they're off there and there's a problem. And we go along and say, well, we've worked that out over a 3-year period. It's going to cost you $6,000. Why wouldn't you just give an undertaking? And they go, yeah, okay. And we do. And it's up. So not giving an undertaking suggests a consciousness of guilt in some ways, doesn't it? It does. It suggests, but we were going to do that. We were going to do the naughty thing, so we don't want to give an undertaking. Anyway. All right, can we move on? What do we got now?
Main topic, quarantining the decision maker.
Yeah. This is a daily thing for us when it comes to managing. We'll talk about the case because there's a great case on this as well. But every day we deal with people dealing with, look, we've got a difficult employee, what are we going to do? Nina would say to them, okay, so who's going to make the decision? You're going to do an investigation. Who's going to make that decision? And everyone goes, oh, I'd be the ops manager, wouldn't? She goes, no, who is really going to make the decision? Because there's a couple of things. When you're dealing with a complex soul, and let's just say they're a red flag employee. I know it's unpopular language, but let's say they've been a difficult person. There's a whole lot of things that everyone knows about that person. You don't want the decision maker knowing that fact because the test for terminating a person in general protection is subjective. The knowledge of the decision maker is everything. So if they don't know they've regularly made complaints about stuff, if you don't know they're always late to work, if you don't know all those things, if all the things that you don't like about that person are not known by the decision maker, all the decision maker does is read the investigative report, and therefore general protections can never apply. So it does two things. One, at the very beginning of dealing with complex matters, get your structure right. Okay, and we've talked about this too often, which is, I know you're bored already, go through your policies, procedures, and legal obligations, create a tick list.
Yep.
Allocate who is the decision maker, quarantine them. Okay, and if necessary, write for the decision maker, I'd like you to undertake an investigation of the following things and provide me with a report so that it's clear what evidence they are going to be given, and don't talk to that decision maker. Don't send emails to them. Just stick by the rules. So why don't we have a quick chat about Pilbara, because it's an interesting case, isn't it?
Yeah, it's Uni of Melbourne. It was a lecturer who was kind of problematic.
I think undoubtedly they were, and like so often happens is when people are problematic and there's been warnings and all sorts of things happen, what they do is they try and sweep it up in a redundancy process.
Yeah, but I mean, it was bad. Like, he was on performance improvement and he deleted
1,000
files or something.
Yeah. So they tried to sweep it up in the redundancy, and then it all sort of seemed to conflate into one thing. And eventually his employment was terminated. And at the end, the judge was
like pretty. So it went to an appeal. So at the first instance, they found that, look, it definitely was the case that they hadn't discharged the onus of proof.
Yep.
And then in the second instance, the appeal court found, yeah, we agree with the uni that there was whoever they said was the main decision maker was the main decision maker, but what they had failed to discharge was to prove that no one else had material evidence.
Particularly the one who was involved in the redundancy argument.
Yeah. And that was the issue. The fact that they didn't provide enough evidence and hadn't set up the process to quarantine decision making. It was too much links.
Yeah, and I guess that's the other part to remember is the general protections have a reverse onus. So once somebody has proved the facts of termination, the onus shifts on you to show what was the evidence that you took into consideration in the determination of termination. Okay?
Yeah.
So what was the state of mind of the decision maker? So if you fail to lead evidence accurately of the decision maker, or the decision maker's evidence wasn't polluted by another possible decision maker.
Yeah, and that's where there was the issue, because the employee just said, yeah, cool, that person told me the decision, but someone else also was the decision maker, and they failed to separate the two.
Yeah. So and look, so let's do the equation. You've got a person who's performing poorly. Okay. You have an entitlement to terminate based on that. You're faced with a decision you need to make about that person, and therefore you need a person to make a decision. That's pretty easy, isn't it? Now, if that person has raised complaints or exercised any workplace right, all that person has to prove is that they were terminated by you and assert that it was for a workplace right. Your obligation as the employer then becomes to show that the decision maker's mind was not affected by a workplace right. It was related to a performance or redundancy related issue. Doesn't matter about process or procedure at all in general protections. So you can see the equation is very simple, but it's that reverse onus that continues to bite. The courts commonly, if it's so obvious that the employer did the right thing, are not as troubled by the reverse onus. But universities and organisations are heavily documented environments, heavily policed by policy and process. So the issue becomes really complex. So the court does dig down to actually identify what was the process. And here they find, well, there's one person who wasn't, but there could have been the second professor who was also involved. You failed to disclose your burden, your onus of proof on that, and therefore the plaintiff wins. So I think it's a great case, you know. I just think because so many people forget the risk of general protections. It's there every time when you're dealing with what could be described as a complex employee. They've complained about staff, they've tried to exercise rights, they've said they're being mistreated. At that stage, quarantine the decision maker.
I will say it was a very confusing decision. So thanks, David, who really
David,
over it by the end.
Yeah, thanks for cleaning it up for us. Why don't we go on to the problem?
Yeah. Gwen felt wounded and afraid. Her manager, Tony, was a misogynist who treated her like a fool. It wasn't just her, but other women as well. He assigned her menial tasks, micromanaged her, and set deadlines that were impossible to meet because he had left things to the last minute. She had tried to raise these issues with him, but each time, in a flirty manner, he would say she was invaluable to him, that he needed her help, and would blame the workload. But Gwen was suffering, the team were underperforming, and upper management was circling. She was scared, couldn't sleep, and often spontaneously cried. She complained to HR. HR provided her with support, offered psychological intervention, and reallocated her to another manager whilst they investigated. When they informed Tony about the complaint, the need to reassign Gwen, and the evidence indicating significant risk in his team, which emerged from the annual People Survey, he claimed he felt blindsided. He said the process seemed unfair and that he felt unsafe. At the beginning of the process, no decision had been made regarding whom HR would report to for the investigation. HR informed Gus, the head of operations, that Tony was being difficult and raised unfounded safety concerns. They explained Gwen's allegations, what she had communicated to them, and what the annual survey suggested, implying that Tony was a problem. HR conducted the investigation while keeping Gus in the loop. An allegations letter was emailed to Tony. Since he primarily worked remotely, they arranged a Teams meeting for the investigation. No support was offered. Tony was stunned by the allegations and surprised they didn't want to meet him in person. He wrote to them again expressing that he felt isolated by their actions. HR spoke to Gus, who stated that Tony was being difficult, just as Gwen had reported. The investigation concluded. The head of HR, Prue, who had
I
previously...
did this on the plane. I didn't have anything else to do.
managed
It's too long.
a performance improvement plan with Tony, presented the findings to Gus, and they jointly agreed that he had to go. A quick meeting was arranged for Tony, which Prue and Gus attended, during which they outlined the findings. Tony's support person remarked that the situation seemed somewhat artificial, and Tony claimed he felt it was a stitch-up. He told them that Prue hated him and had mentioned at a social event how difficult he was being, which was true, though he'd also been difficult at the event. Gus said, "Enough, we will take a break and come back and let you know." All the allegations were vague and impressionistic. Tony argued that it was unfair as he couldn't adequately respond. When they returned, they summarily dismissed Tony. He was stunned. Nothing in the allegations letter or the allegations themselves had suggested he was at risk of termination.
It's got to be, isn't it? Okay, so...
Hey, there's no tricky words.
No, which is longer.
Yeah.
Were Tony's alleged actions psychological hazards?
Yeah.
Absolutely. Terrible. So Tony was in deep trouble. And interestingly, wherever you get in this, the court's going to look at Tony's actions, and he's in a lot of strife.
Yeah.
Okay. Would Tony have a valid workers? Absolutely. The process that was undertaken against Tony.
There's no defence to
the
that.
use of video, all the things that we've talked about in the past. Yeah.
Especially because he raised the concerns and then they just dismissed it out of hand.
Yeah. Was the manner in which he was investigated the safety risk to Tony? Did it breach any safety law?
Yeah. It exposed him to psychological hazards.
So yes, it did. Can you remember the case we did the week before where we talked about the use of videos, the conflicted interest in the HR who had already participated in issues? I just chucked them all in again to remind you, when you're investigating someone, don't have Nina investigate me when she's dealt with me adversely before, because no one's going to believe that's fair.
Yeah.
Okay.
Even if what your investigation is fair, it just is tainted.
It's tainted. And remember,
you know, allegations. An easy way for them
allegations are date, time, place, person, and fact. They're not impressions. Anyway, I just thought I'd chuck those in as a reminder.
Was the investigation fair? No. just
so
for the reasons that we just talked about.
Could Tony argue unfair dismissal?
Yeah.
Absolutely, for lack of procedural fairness.
Yeah.
If he did that, can I just say to you, the organisation would take a terrible bollocking, but Tony, if he succeeded, would get little or nothing, but he may also just fail. But in a general protections claim, he has a winner.
But then that's not the reason they're terminating him.
Oh, they are. No, because what they kept saying all the way through is HR, Tony's a difficult person. So there is a secondary narrative, and I put this in deliberately. If you and I are decision makers.
Oh, because of all the discussions
that occurred to it, then who is the real decision maker? One. And two, if mine is a frustration with this person for being bad and difficult, then I've tainted it and I will not be able to get out of my reverse onus. So this is a case around not being able to defeat the reverse onus.
Tricky.
Yeah, tricky case. That's what happens when you have an hour on the plane. All right, look, can I just say thank you very much. We really sped to get here. Well read, well done. And hello to my dad, and see you later.
See you next week. Bye.
Cheers. Bye-bye.